Welcome, friends. Today, on behalf of Beyond Law CLC and the ULS Punjab University Chandigarh, we welcome you all, even though it's a Sunday. But we are quite happy that people are willing to latch upon an opportunity to improve their knowledge, and that too from Mr. R.Venkataramani, who is an established name in the legal field as well as the teaching fraternity. He has written various books which are widely read by the academicians, students, and the lawyers, since it facilitates to them with law as such. Mr. R. Venkataramani is a senior advocate. He has acted pro bono in large number of cases. He has been appointed amicus. He's a former member of the Law Commission. He has been conferred the award of V.R. Krishna Iyer. He has taught in National Judicial Academy, NLU, Global Law General University, whatso. He has in his resume so much that in fact the entire session can continue upon his what are his benefit, what knowledge he has, etc., etc. And today, amongst us, we have also Mr. Bimaldeep Singh, who is a known name in GNDU and across the other academics side. He has, if we go through, he has taught various subjects in GNDU. The students personally feel that if he is teaching in A section, the students of C section and B section feel that they should also get an opportunity to hear him. We have a pleasure welcoming Mr. Bimaldeep Singh, who is in GNDU University. Welcome, Bimaldeep ji, and a formal welcome to R. Venkataramani. So welcome to both of you. And all, we will have the Q&A session after around 50 minutes. You can post it on the chat box, or you can ping it at 98725-03300. And the rules of the conditions of the chat box are, as well as the questions would be, that they should be correlated with the subject. Thank you, everyone. Over to Mr. Bimaldeep Singh.
Thank you, Vikas ji. Guru Nanak Dev University finds pleasure that Beyond Law has associated itself with the Guru Nanak Dev University, and they are doing wonderful work during this pandemic of Corona. So as the participants, they have been already apprised of, today senior advocate Shri R. Venkataramani ji, who has represented the various cases on behalf of the Union government, including Michael B. Fernandez versus C.K. Jafar Sharif, and he has been a member of Law Commission. He has been on the panel of Law Commission, O.P. Jindal Law School, and as Vikas ji has said, his introduction will take volumes, that the session may have to be carried to another 2 or 3 sessions before the introduction is completed. So not going into those repetitions, freedom of speech and expression, as we have been trying to understand, it can be said that everyone wants to be a voice and not an echo. So every constitution, even when there is not a constitutional setup in existence, if we look into the Voxist concept, if we look into the social contract concept, the freedom of speech and expression is a basic requirement which any organization or individual, while making a status to contract or vice versa, is seeking to achieve. But it is a tyranny which Shri R. Venkataramani ji will be explaining and elaborating in a detailed manner, and taking us to the depths and heights of the whole aspect. basically, what we feel is that, as the topic itself suggests, the freedom of speech and expression, good times, bad times. So, how there are good times for the freedom of speech and expression, that will be explained by the keynote speaker of the today in a detailed manner. But sir, uh, as far as I feel, that whereas an individual has an inherent right along the freedom of speech and right to life and liberty, a freedom of speech and expression to say whatever is there, and the many dimensions of that, as we are understanding, are right to know, RTI, and these televising rights, broadcasting rights, social media. So there are adding dimensions of those fundamental rights, and as we have been taught as a students, and we have been teaching to our students, that basically it is the Menka Gandhi case which has uh, as a, what we say, as a Trishanku, uh, for the first time has given this opportunity what ADM Jabalpur and AK Gopalan case has restricted, and rule of law even has been understood in a restricted sense. So, as far as my understanding is that freedom of press, which can be seen as the highest manifestation of the freedom of speech and expression in India, uh, that has not a parallel in the USA, where after the First Amendment, it has been given that status. But still, it is our judiciary, starting with Ramesh Thapar case, with a series of Indian Express newspaper cases, information broadcasting, then the latest which I have in mind, and it has been an issue in the consideration. So every state has a reservation that such kind of freedom of speech and expression which an individual wants, so that struggle continues. So I will now wasting much time and standing between you and uh, uh, senior advocate R.Venkataramani ji, will pass the ball to sir to address these and various other issues.
Thank you so much. And Ms. Chatrat, it's a great pleasure to be with all of you today. And on Sunday, as you said, to be able to gather oneself to listen to a subject like freedom of expression, a very heavy subject, a dense subject. And while we ramble along and look at what freedom of expression has meant across time and across space, we still find that the difficulties and the problems which confronted human beings, maybe when Greece was trying to be a democracy, and when Confucius was a leading lodestar in Chinese thought, and when Indian thought allowed the Charavakas to say what they wanted to say. Regardless of all that has happened over the past 1,000 and odd years, we are still confronted with some fundamental problems. And as a US Supreme Court Judge Justice Brennan put it in an obscenity case, he said, I tried for more than 15 years to understand what is it. If I can't define it, I think it's better not we prosecute people when we can't define what is obscenity. So we'll find out in course of time that the problem of definition in constitutional law is so fundamental. And as it is so important when the state has to exercise its powers of restriction on any fundamental right. Now let me start with Either you talk about something very beautiful about freedom of speech and expression. That's why when I said good times, bad times, I thought about this dimension or the division. Can we say that any part of human history in different civilizations, there has been a good time for freedom of expression? Can we say that freedom of expression, with all its manifold forms, had enjoyed a flourishing period without any restrictions, impositions, censorship, regulations, and so on and so forth? So I want to start with this proposition that expression is antecedent to every other aspect of human behavior. And in the context of our constitution, to every other human right. When you go into the animal spaces, you will find that large and small animals make tools. Crows make tools. Birds, many birds make their own homes. And they make tools and use them. And birds have a brain, a fraction of the chimpanzee, but use the tools all the same. Humans and chimpanzees share the ability to transmit behavioral patterns socially. However, what the chimpanzees do, even though we admire what they do, what the chimpanzees do pales in insignificance compared to what humans can do and are doing. The human foundation of expression, its manifold forms of speech and language, art, music, culture, or other social activity. Remember, when you talk of music, whale song or bird singing also is said to be, hummingbirds is said to be part of music, but while it's not music, and truly it's not the same. So this is the first thing that separates us from and elevates us from the status of animals, namely the ability to comprehend and communicate to each other through a variety of means and forms. Next. Historically, I think we may also keep in mind two key aspects of culture and social transmission. What are they? One is storytelling. The other, by and large, has been religion. And both require language. The evolution of language made it possible for us to cohere our thoughts. The ability to comprehend and explain the world outside and what we do inside our brains and minds are deeply relevant to our capacity to express. But what does this ability do to us? In what ways does this ability give to each one of us a fulfillment and social bonding? You mentioned about the difference between being an echo, right? So while we examine the evolution of freedom of expression as antecedent to all other rights and the fine connecting thread of several needs and rights, we need to understand that the ability to express brought in also the need to express. The need to express fulfills several other individual and social needs. One, knowing the truth and transmitting is one basic need. What we call information world today. This facilitates social ordering and survival. And as we move on to democracy, this facilitates a wide range of factors and dimensions. As we move on to human history, this also leads to science and technology, to philosophy, to law, and to justice. The connections are very real and intricate. Now, we have mixed stories in ancient India, Greece, Rome, and China. If you look at what happened, for instance, say in 200 BC, Confucius was said to have broadly, informed the thinking and the moral standards in Chinese society. People were expected to know their place. Kings ruled their subjects, so fathers over children, husbands over wives. The powerful were expected to behave with benevolence, and failure to do so could result in forfeiture of power. Of course, this was theoretical. The reality was often different. Nevertheless, one looks at Chinese history, for the first millennium, this system allowed a civilization to flourish and a variety of thinkers of many persuasions to debate ideas. Switching over from an ancient China, you come to modern China when 1919. I want to bring the link quickly so that without wastage of time. In around 4th of May 1919, 3,000 students demonstrated at Tiananmen, the gate at the front of the Forbidden City in Beijing. Incensed at the news that a treaty of wassail with China was not going to hand back former German colonies on Chinese soil. But in 1915 and 1930, reform-minded Chinese looked in every direction for solutions to real problems of militarism and imperialism. And you'll also, amusing to notice that Mao Zedong, who came to rule China for a long period, was part of this, the 1919, the student agitation. Now, if you switch from China to go to ancient Greece, so we'll see that in ancient Greece, Athens was a great citadel of democracy. But then we have a story of Socrates, and whose very powerful ideas led ultimately cost him his death at the ends of poison. Now, and Ali was talking about what happened in India, the Charavakas, and then you have a long history of heretical, non-conservative, unorthodox writings both in philosophy and literature. Ending from even if you look at the Middle Ages, the voices have not been very silent. And so you can find parallels between Greece, Rome, and China on the one hand, theoretically, where people have been able to express themselves freely, but on the other hand, the imperial impositions and the monarchical, censorial regulations are well-known stories. But if you look at again what happened in Europe, so a huge story of several volumes have been written about the conflict between religions, is Christianity and Islam, was several hundred years and centuries after centuries. And we have a church maintained, index of forbidden books, which included a wide range of authors, scientists, thinkers, writers, who could probably criticize the church from within and outside. So we have the story of a Spanish Inquisition in Europe. And I was talking about the index of forbidden literature, which commenced somewhere in 1544, came to an end only in India in 1960. So if you look at globally, people have been the fundamental urge, which is a fundamental need to express yourself, one towards individual fulfillment, and the other towards a social contribution of enhancing the quality of the place and the community where you live. Both are intricately connected. If the urge to have individual fulfillment is absent, I think you will not be in a comfortable position and to contribute to enhancing the quality of the community, and vice versa. Therefore, the connection between the urge and the need to communicate, between the fundamental need and the urge to communicate for reasons of one's fulfillment and for community fulfillment, are very important. So I think the constitutional idea of expression, a free expression, is thus the birth product of a long story of civilizational struggle. Fortunately for us today, we live in a century, for most of us, freedom of expression is now a universal demand. And except in few totalitarian constitutions and societies, this freedom occurs and occupies an important space in the constitutional landscape. But then, free speech is nowhere permanently established and uniformly or fully enjoyed, even after constitutional revolutions and the Universal Declaration of Human Rights and so on and so forth. For instance, opinion research suggests that while a majority in the United States, for example, supports freedom of expression in the abstract, a majority also opposes much free speech for those espousing views quite different from their own. When you go to Japan, survey indicates that in Japan, college-educated adults now express more confidence in the 1947 Constitution than in any other national institution. Article 21 of the Japanese Constitution is equivalent to Article 19(1) of the Indian Constitution and the First Amendment of the US Constitution. So, but then interestingly, why did he talk about good times and bad times? I gave a brief, prelude. Now, we thought that we gained independence in 1947, we were in good times. We were free from the colonial masters. Constitution gave us a lot of aspirations. Freedom to talk, freedom to express, freedom to move around, freedom to engage in trade and occupation. Those freedoms which are probably not even conceived. And now with that hope, the Constitution began its long march in 1950. But soon, if you find the Article 19(1) as it then stood before the First Amendment of the Constitution, and as it was amended after the First Amendment, there were considerable differences. Soon after the Constitution came into force, we had two important decisions, Ramesh Thapa and Brij Bhushan. And we also had a case. It came from the state of Bihar. The state of Bihar versus Shaila Bala Devi, a printing press owner, which in Bihar was prosecuted under the Indian Press Emergency Powers Act 1931, a pre-constitutional law, as she published a leaflet in Bengali called Sangram, calling for revolution in India. Ramesh Thapa hugely criticized Pandit Nehru's foreign policies. And then we have in the Shaila Bala Devi's case, the High Court of Patna had something very interesting to say. Chief Justice Sarju Prasad held in that case, while doubting the prosecution, that a person who preached murder and incited violence had the freedom to do so under Article 19(1) of the Constitution. When we talk about regulations having a chilling effect on freedom of expression, soon after this judgment came, the parliament and the government thought it's going to have a chilling effect on the government's ability to really deal with incendiary statements. The First Amendment came soon thereafter. And if you look at the parliamentary debates and the concerns expressed about what a judgment can do and to enlarge the scope of freedom of expression are very interesting. In fact, when the First Amendment to the Article 19(1) came, there were different points of view. Shamu Prasad Mukherjee said it is going back to the pre-First Amendment US constitutional position. And Rusi Karanjia in Blitz called the First Amendment bill a black bill and a rape on the Constitution. So we find that even the word reasonable, which did not find a word prior to the First Amendment, necessarily came in the First Amendment to Article 19(1)(a). And now public order and incitement to an offense became an integral part of the reasonable restrictions on Article 19(1)(a). While we'll see that over a period of time, the several dimensions of the freedom of expression underwent a sea change, and whether in the context of sedition, whether in the context of dealing with pornography, obscene materials, or in the context of the freedom of the press, and including the fringe issues such as whether an advertisement would qualify. In Hamdard Dawakana case, an advertisement would qualify as protected under Article 19(1)(a. We'll see all those wide range of cases confronting the Supreme Court as to engage in a very serious debate and deliberation on delineating the outlines of Article 19(1)(a). So if somebody from 1950 travels to 2020, probably they may exclaim as to what they may also talk about Article 21. Just to give a brief example. So what was conceived to be a bare pro-liberty provision in Article 21 has now become a basket containing several rights and claims and interests. So also if somebody in 1950 comes to 2020, you will find Article 19(1)(a) has probably reborn and then added so many shades and dimensions which was probably not conceived of when the Constitution was enacted. I'll just give you two illustrations. One, we have the S. Rangarajan versus Jagajeevan Ram case, a very important proposition laid on by the Supreme Court, where court said, which is a 1989 2 SCC 574, the Supreme Court said, in a democracy, it is not necessary that everyone should sing the same song. So it, in a pithy way, it propounds the importance of diversity. Diversity is of human mind and thought. Diversity is in forms of expression. Diversity is in using mediums of expression, and the need to protect all those variety of diversities. And then we have, even though a slightly diluted note was added to the Supreme Court a little later in one case called Bargur Ramachandrappa versus State of Karnataka. Now, therefore, it's important for us to just look at, is there any connection between the reasonable restrictions and every form or medium of expression? So you find there are, in respect of each form of expression, the connection between the form of expression and the nature of restriction does not admit of one universal standard. So if it's in the case of mere, incitement to violence, etc., we have the old statement by Justice Holmes and crying fire in a theater. So the propositions of Justice Holmes came into somewhere in the year 1919. But the question of fire in a theater is will it hold good? And then if the incitement to an offense by exhortation of using strong inflammatory words and expressions, either in an article or in a speech or in any other form, and what are current standards when we find that the society's ability to handle diversity coexistence seem to be in peril. The society's ability to handle diversity coexistence, if it's a fragile fabric, then the concepts used, developed, for instance, in a different context, maybe 100 years ago, may not yield and sometimes may have to undergo radical changes. We'll have to wait and see about that. So what is important also to notice in this context is, while we see that courts have tried to explore the connection between the speech, the writing, and the consequence, and whether it should be proximate or indirect or remote, in a 1989 Supreme Court statement, the court said the proximate connection between speech and public order must be that of a spark in a powder keg. While it is beautifully stated, how do we really apply it in concrete situations? And what exactly would qualify for a spark in a powder keg? Just to offer an example from the Japanese constitution, public welfare is a ground on which reasonable restrictions could be imposed on freedom of expression. So over a period of time, when unions have sought to express themselves against policies of the state and in employment-related matters, questions arose whether public welfare is such a flexible, so wide, so which can yield a wide range of connotations. So we have, whether it's the concept, the word uses public welfare or the interests of general public or public order, somewhere we will still have difficulties in delineating the outer limits of these concepts. Because on the one hand, regardless of the fact that the state will not play a biased game in any particular freedom of expression situation, but the state has an obligation to ensure public order anyway. So the state's understanding of public order and its extension can be sometimes problematic, which is why we fall upon, come to the court and say, look here, this understanding of the state in a given circumstance probably is either excessive, not proportionate, or fundamentally wrong. So we have 3 or more outcomes which are possible. We're using well-known concepts in English administrative law, which we have borrowed heavily and used them in a wide range of circumstances. Like fundamentally, it's something is illegal, unconstitutional, in plain language, or it is not so proportionate to the action taken, or so also we say it is excessive, and so we have all these problems. I started saying that the right to freedom of expression is something which is antecedent to all other rights. There have been some debates in the international level, particularly during the Cold War era, when we have Soviet Russia on the one hand, and then the rest of the world on the other hand, talking about the importance of economic and social rights. The Soviet Russia emphasizing poverty, removal of inequality, social and economic rights. And the Western world is talking about political and civil rights. With the collapse of the Soviet Union, and then much later to a large number of interventions at the international level, we have now seen a development that all rights constitute one integral whole. You can't put them in isolated compartments. But even that is so, if the right to freedom of expression is one that which informs, facilitates, and is antecedent to all other rights, its importance is certainly can't be minimized. Now, let me tell you how sometimes an incitement to speech, I'm talking about, let's say I talk about bad times. I'll just read you a small incident that what happened in Germany around 1943. It makes a very chilling reading. Let me read it. It reads like this. One day in the summer of 1943, Erna Petri, a homemaker and a wife of a senior German officer, was driving home from a grocery shopping and noticed 6 frightened children, dressed only in shreds of clothing, crouching along the side of a country road. She had heard that number of Jewish children escaped from a boxcar as they were being transported by train to a Nazi death camps. She suddenly realized that she had come across a group of them. She told the frightened children, aged 6 to 12, to come with her. She brought them into her home and reassured and fed them. Then she led them into the woods by her house and shot each one of them in the back of the head. Years later, when this German mother of 2 was asked how she could have committed such a heinous act, she replied, I quote, I am unable to grasp at this time how in those days that I was in such a state as to conduct myself is so brutally and so reprehensibly, shooting Jewish children. However, earlier I had been conditioned to fascism and the racial laws which established a view towards the Jewish people. As was told to me, I had to destroy the Jews. It was from this mindset that I came to commit such a brutal act. Now, this reminds me of what happened, for instance, in Egypt, long years ago, when the Egyptian pharaoh Amenemhet is recorded to have incited against other ethnic groups in a region, whom he would ultimately slaughter and enslave by describing them as animals. He is recorded as boasting. He says, I subdued lions, I captured crocodiles, I repressed those of Wawat, I captured the Medjoy, I made the ass do the dog walk. Do we want to hear the same kind of rhetorical, incendiary speeches and talks, which would continue to inform the fabric of Article 19(1)(a) of the Indian Constitution, and even at the universal level, whether intolerance of a point of view, intolerance of any diversity, intolerance of a behavior, intolerance of an attitude, intolerance of a belief. You can go on adding to this. So in a social order where the fundamental informing principle is cohesion, accommodation, understanding, compassion, and give and take. You can probably expand on all this from any philosophical point of view. I'm not going to enter into that. So, but if you just come back to what the Indian Constitution has done. In current times, we have recent examples of journalists and media persons going to court, members belonging to legal fraternity talking about what governments ought or ought not to do, which properly one may disagree with what they may say, the way they say, and the contents of what they are talking about. And the courts are now confronted with not only the two strands of thought which they have evolved over a period of time, where, as I said, in Rangarajan's case, where the Supreme Court said, in a democracy, to repeat, in a democracy, it is not necessary that everyone should sing the same song. But the question is, when you want to sing a different song, how will you sing it? What forms you will use? And what limits you will not cross? Can we have an inflexible regulatory regime brought into the freedom of expression, which I say is something so fundamental? So in order to limit what song one can sing, in what form and in what manner, to what extent, and are these limitations on freedom of expression can be legitimately brought into a constitutional framework, or we should ultimately probably appeal to a larger social consensus and understanding, which would not only inform citizens, but also inform law enforcing agencies and courts. I'm just reminding myself of a farewell speech made by Justice Deepak Gupta and laying down office. He said, I swear, not my Bible, the Gita, the Bible, the Zendavasta, the Quran, all that for me is the Constitution of India. A very, very important statement by a judge demitting office. If this understanding will only inform not only the legal fraternity, but the law enforcing agencies, our legislators, and citizens in general. So can we, therefore the question to be asked is, can we so organize our social order and our understanding of the importance of the Constitution in our everyday life that the right balance to be drawn? Now, stopping here for a minute, because you'll find very often in several jurisdictions, and when you go to the European Court, looking at issues of freedom of expression coming from a variety of states, it talks about proportionality and balancing. The concept of balancing is very often used in different circumstances. So balancing the rights and claims of the underprivileged and the rich, the poor and the established. So we talk about balancing excess and the need and the minimal need. So is it possible that the concept of balancing can be given a constitutional or a legal framework? These are very important questions. And if the current debate, for instance, again, and the First Amendment literature in United States is both rich and diverse. It's also problematic. We cannot probably mechanically borrow them and fit them like a Procrustean bed. So we need to look at some of them and see how in different cultural, social, and historical settings, the principles that have been evolved under the First Amendment of the US Constitution and can be profitably imported into the Indian constitutional structure, having regard to our own peculiar social and cultural needs and diversities. Well, on the one hand, one may say universally, there is no, except few countries in Europe, or even some of them may have the diversity elements present. The majority of our countries in the world today have diversity, dimension. And the degree of diversities may differ, but diversities all the same remain. Therefore, when we talked about freedom of expression, and as I said in the beginning, that freedom of expression, to emphasize that statement, that for my own fulfillment, like when you sing a song, when you play music, or you play in a theater, or write a poetry, or do a painting, they are matters of fulfillment for you. But at the same time, you would probably like to convey a message, an idea, an understanding, a position, an attitude, a perspective through what you do. While singing in a bathroom is different from singing in a theater, an open theater. And therefore, when you want to convey your personal longings and understandings of what a society should ideally be and how human beings should order their relationships, etc. So the forms of expressions, and between the forms of expression for a personal fulfillment and the forms of expression for a community fulfillment may also sometimes radically be different. So what can be a benign form of expression when it is only an expression for your personal fulfillment, and when you try to translate it into a community expression, there can be problems, and vice versa. You won't probably use a violent or very excessive mode of a form of expression, which may ordinarily use in rhetorical utterances when you are engaging in music or art culture for personal fulfillment. So I ask myself a question. When for a personal fulfillment, you practice restraint, understanding, and the same dimensions of restraint and understanding, and why can't we ever be vigilant in translating them and converting them and reshaping them in whatever manner would be appropriate when we are in the public domain? So the cases in current period give us all these dimensions. So we have either I have one problem with a matter which has now come to Supreme Court and the need for fundamental legal reforms. For instance, if somebody had to say something in a public media, and if there are opposite points of view, should the law permit all possible opposing points of view to engage in a prosecution of this gentleman or gentlewoman? And should there be some kind of a way where the ability to oppose a wrong point of view can also be expressed in a more non-abusive way? We all talk about abuses and excesses against freedom of expression. But then why do they come? So as long as there are no more tolerant, reasonable, and dignified way and more respectful way of presenting your opposition to a point of view, we will continue to have all of these issues confronting us. So people will always, of course, when in the Dr. Subramaniam Swami's case, when the defamation provision in the CRPC, Supreme Court held it still to be constitutional. I'm not very sure whether the court could have gone a little ahead and taken a different view. So we have, as I said, whether in the context of sedition, we have serious and very important concerns arise in contemporary times. Universities are important places of debate and deliberations. And centers of education are the more appropriate places where the foundations for deliberations and debates of wide range of sorts can emanate. So if sedition, which is an outdated law, let us say, in different parts of the world, and will continue to occupy the legal landscape of a country. That's one example. So we can have other examples like Section 295A of the Indian Penal Code. And even if you look at 153A of the Indian Penal Code about promoting enmity and communal hatred, etc. I think there's a need for more finer refinements of these legal provisions. In order that we understand, on the one hand, the fundamental need to express oneself is in no way impeded, except on very clearly felt reasonable limitations. But on the other hand, the need to express and the forms of expression, the contents of expression, how do you really moderate them? How do you really ensure that there is no excess? So they're very difficult questions and answers. So I'd probably, for instance, to give you a few more instances, how sometimes they can be very hilarious. I have a list of what happened in 2014 in USA, the kind of cases which came to 2014. So somebody had labeled her cheese creamery in as a skimmed milk. The Florida law required skim milk to be artificially enhanced with a vitamin A because thought if it is not done so, the state says it has serious health consequences. So under the Florida law, unless she described her product as a non-grade A milk product, natural milk, vitamins removed, she would not be able to sell a product. Then she says, I don't need to do what the state is asking me to do, and because of the right to engage in a truthful speech about what I am doing and what I am selling is part of my First Amendment right. So we have, on the one hand, this kind of cases like this. Then we have another case, an anti-abortionist. There was a Massachusetts law which created a 35-foot anti-protest buffer zone around abortion clinics. And this was challenged as unconstitutional by an anti-abortion activist. The Supreme Court unanimously agreed that such buffer zones were not illegal per se. This particular law was not narrowly tailored enough to suffice. The court said, for a problem shown to arise only once in a week, in one city at one time and one clinic, creating a 35-feet buffer zones at every clinic across the Commonwealth is hardly a narrowly tailored solution. Then we have another interesting example. A New Jersey college professor posted a picture of his daughter on Google. In the photo, the young girl was wearing a Game of Thrones, a t-shirt featuring the words, "I will take what is mine with fire and blood." The college where the professor was engaged took this as the professor making a threat, suspended him without pay, and ordered him to see a psychiatrist. Months later, the college acknowledged that it may have lacked basis to sanction him for the shirt and potentially violated his constitutional rights. We have another case from Texas, where a Texas activist who was arrested several times for taking pictures of police officers in action to go forward about the prosecution. The decision noted a robust consensus of circuit courts of appeals that the First Amendment encompasses a right to record public officials as they perform their official duties is protected in the First Amendment. Then, later, the trial court found that the activist not guilty of the criminal charges. In North Carolina, Circuit Court struck down a law requiring physicians to perform an ultrasound, display a sonogram, and describe the fetus to women seeking abortions, because the court thought the intent of these directives is ideological in nature and they represent compelled speech and others in violation of the First Amendment. You have a wide range of interesting examples in 2014 and much later. Let's just go to a country like Brazil, and I'll probably close for a question answer session. Brazil has tried to adopt the US First Amendment principles. And in a scholarly review of what happens in adopting the First Amendment principles in the context of Brazil, there are I'll read you 3 or 4 cases which came in Brazil, and quickly. For instance, Hitler's Mein Kampf book was banned in Brazil on the ground that it amounts to incitement and hatred against Jewish community. And the court found there was a legal justification for this ban. And the Superior Court in Sao Paulo said this is not a simple expression of religiosity, something that could perfectly happen in the interior of a temple, but in wide open, a public space. Then came a federal Supreme Court in Brazil, which ruled in favor of public demonstrations that defended the legalization of drug use. The court expressed the opinion that the constitutional rights of freedom of assembly and freedom of expression must be respected. It also opined that the marches should not be considered crimes because they do not foster or defend the use of drugs, but rather are designed to bring about a review of public policies. Then, in yet another case in 2014, one of the former candidates for the presidential election was extremely critical of the gay, bisexual, transsexual, and transgender movements in Brazil. And his extremely critical statement came to be a matter of intense debate. The Sao Paulo High Court considered the statements of the presidential candidate had exceeded the limits of a freedom of expression, focusing on hate speech. The court said we cannot prohibit the candidate to express his opinions. However, he used extremely rude, hostile, and unfortunate words that offend persons who are human beings and deserve respect from society. The equality principle should be followed. Besides, the offenses made the JLS population propagate the false sentiment of a political legitimation of a discriminatory behavior, strengthening acts of exclusion and violence against the minority. This kind of discourse is a disservice to a democratic society, which is what our Supreme Court said in Rangarajan case. In a further case, in 2003, similar, like Hitler's Mein Kampf being banned, a writer and a publisher who wrote on anti-Semitism, the crime of anti-Semitism, he was prosecuted. And in Brazil, the Constitution, Article 5.42, determines that the practice of racism constitutes a crime, neither subject to bail nor to the statute of limitations. Arguing that Jews are not a race, the person who published alleged that the crime of anti-Semitic discrimination for which is condemned does not have racial connotation necessary for barring the statute of limitations. The court disagreed with him. The justices understood that in that case, the conduct of the petitioner in publishing books with anti-Semitic content was explicit, revealing a manifest intention to deceive, as he himself on the wrong premise that the Jews are not only a race, etc. It was decided that as any individual right, the constitutional guarantee of freedom of expression is one absolute as it will be retracted when it oversteps its moral and judicial limits, as in the case of immoral manifestation that amount to penal violation. So the character of the Brazilian debate proceeds on how the shades of US understanding and the First Amendment, whether it will fit in the Brazilian constitutional dimensions. We have a same kind of a debate in India. So we have several instances happening across the globe. Restrictions on medium, restrictions on media, restrictions on press, and on the one hand, restrictions on individual freedom of expressions on the other hand, and the excessive, non-deliberated statements by individuals or media again, and these are the three dimensions which confront us currently. I don't think the answers which Supreme Court has given so far would be sufficient enough to deal with them, but we have very significant and answers which potentially can be conveniently explored. So at the same time, see, as I was talking about the fundamental fulfillment aspect for an individual. Now, how do you express yourself in the absence of freedom of expression about one's identity? It can be race, it can be religion, it can be an attitude, it can be gender, it can be sexuality, it can be sexual orientation, it can be caste. So as long as these facts and factors are part of human civilization, and as long as we have difficulties in accommodating them as part of a diversity of human civilization, I think the fundamental need to freedom of expression, to be engaged in dealing with these concerns and interests and claims cannot be, I think, overemphasized. If you think, I would probably stop here and for taking questions.
So if you feel it's we can do with the question and answers, or we can also go ahead with the session also, because ultimately the people would just like to be enlightened upon the law. It is only the different facet.
No, if there are some questions which have come on what I've spoken, if I can pick up on that and then, yeah.
I will just read 3-4 questions that have come, others people can start messaging it. Sumiti Jain, words can hurt as well as heal. In today's era of social media where fake news and messages are causing so much damage to a person and property, what interpretation methodology of law should be used to control such incidents?
No, the first dimension to this question is, how do you believe the truthfulness of what is being stated in the public domain? So can you, anticipating or on a prima facie impression of what is being stated, I will currently come to some impertinent statements, probably excessive statements being made in the social media about COVID-19 and related issues and probably some other issues. I'll currently come to them. But the question is, whatever be the circumstances, can we, in ante, say that, look here, all false statements, all statements which are excessive, prima facie, in the understanding of the state, are explicitly forbidden. So, unless we erect a threshold frontier or threshold limitation, even on the state's understanding of what is permissible and what is not permissible, and what is truth and what is not truth. So therefore, on the one hand, if on the social media a wrong statement is being made, is the antidote a criminal prosecution, or is the antidote something else? And either other more liberal and more reasonable ways of handling these excessive statements in let's say in online medias. So we have seen that in the defamation cases, we have all this debate in defamation cases. What is true? What is said about somebody? So qualified privilege, absolute privilege, all those issues have come up before the courts. So an absolute privilege may not be a defense, or maybe a defense. These are matters of debate. But then once a prosecution sets in, and prosecution becomes an oppressive machinery, then the long drawn, a criminal process is itself is vexatious. So therefore, we have to look into more than one dimension. The need to quickly jump into conclusions. I understand there is a public interest concern, but at the same time, are there more, as I said, reasonable, more legitimate ways of looking at and handling these issues? Look at the national anthem case. The public honor, that Act of 1971, if I remember correctly, does not make it a crime for not honoring a national flag while national anthem while being played in theatres. The Supreme Court made it a controversial issue, and post Supreme Court statement about national anthem and the need to stand up and honor the national anthem, I'm told there are a number of prosecutions in different parts of the country. So can Supreme Court make somebody liable for a criminal prosecution when there is no authority of law? And so question would be, who will verify what information and to what extent is truthful or not truthful? We need to evolve a mechanism to deal with this question.
The next question is, then why Mahmoud, a journalist of Al Jazeera News channel, is jailed in Egypt from last 1 to 3, 4 days and will continue further? As per Article 19 of the UDHR, includes freedom of press. What is your take on that? This is by Himansh Kanda.
Which one?
So Himansh Kanda, he has posted at 12:20.
Yeah, can you come back a little?
So 12:20, he poses a question. I'll read it. Being a freedom of expression, a universal right, and comes under Article 19 of United Declaration of Human Rights, and why Mahmoud Hussain, a journalist of Al Jazeera News, was jailed in Egypt for last 1 to 3, 4 days and will continue further? As per Article 19 of the UDHR, includes freedom of press. What is your take on it?
See, the Universal Declaration of Human Rights, and you'll also probably look into the Cairo Declaration on Human Rights. So in the Islamic world, the Cairo Declaration on Human Rights sought to bring in some kind of limitations on the invocations of the Universal Declaration of Human Rights. So whether you look in terms of the Cairo Declaration of Human Rights or the Universal Declaration of Human Rights, the question is the continued detention of this gentleman within, is it permissible within the Egyptian constitution, is a question. So if the Egyptian constitution and the Egyptian Charter of Fundamental Rights provides that you can invoke an international law principle for dealing with a domestic law issue, even when the domestic law is silent on that question. So the issue is not whether we can invoke an international law principle or not, because the Universal Declaration of Human Rights, followed by a wide range of international instruments such as covenants and conventions, etc., have now become verily an integral part of domestic legal discourses. And to a large extent in countries like India, and to some good extent in some of the South American countries, and also South Africa. And if you look at some other constitutions and newly liberated constitutions in Eastern Europe and Herzegovina like that, you will find that the invocation of the international principles, international instruments, and integrating them as part of the domestic law principle happened in a big way. But even if that does not happen, the question is a domestic court competent enough in terms of its own constitutional framework to deal with a situation like this? That will be the question. So we'll have to examine the Egyptian constitution, the competence of the Supreme Court of Egypt, and so on and so forth. So the question is not answered by merely falling back on Article 19 for the Universal Declaration of Human Rights. That will be one tool.
Mrinalini Deshmukh asks, how would you distinguish between irresponsible and sensationalization of media and fake news and freedom of expression?
So you have all this. Well, 1 minute. Let me just catch that question.
1227, I will read it. How would you distinguish between irresponsible and sensationalization of media and fake news and freedom of expression?
Okay. See, Europe has seen after all those insulting public display or descriptions of Prophet Muhammad, and then we had a series of terrorist actions in Europe, in Paris, and in Denmark, and Germany, in Russia, and in virtually almost every state in Europe. And when it comes to the question of whether people who engage in supporting such activities, do they have a freedom of expression? Question is not whether they have freedom to express or to say, let's say, what is done as by way of a terrorist activity is just, and it is correct, and it is legitimate. But if you're talking about the freedom of expression, to have a defense in a court of law, and a fair trial, and a trial, etc., I think you can't say such a freedom of expression is prohibited. So the line to be drawn between a freedom to express views which are fundamentally opposed to a security of a state or the integrity of a state or public order, etc., howsoever narrowly you may define them. So England had this problem, France had this problem. The question is whether you should narrowly define public order, interests of the state, security of the state, so on and so forth. Whether you narrowly define it and widely define it, the threshold will be ultimately as to whether somebody can engage in a statement or a propagation of engaging in violence. So the answer would be obviously no. So the question is again, the irresponsible and sensationalization of these issues and fake news and extreme media, in the media. Now, my understanding of this, if what is not permissible under law, under the Constitution, and the universal, international principles of law, and there can't be the media or the forms that are being used to talk about or debate these issues cannot have a higher level of protection. So if utterance cannot have protection, the form through which these utterances are made cannot also have a protection. So the media cannot have a higher level of protection when they engage in unprotected activities. If unprotected activity falls, the forms of expression through which they are communicated should also fall. There can't be a different standard.
Wahid, how is this expression of expression working on the ground, as it tags one group with sedition while other group as a patriot while uttering the same? Is there any distinction between the two?
Well, suppose if the law of sedition remains, this distinction will continue to remain. Because the debates will be like, am I engaging in a speech which is prejudicial to the interests of the state? I may try to portray a particular government or a particular political party so in a poor limelight. And do I have freedom of speech and expression to do that? And the question is not whether I cross a limit. The question is whether statements made in criticism of public figures, people in positions of power, governments, etc. For instance, see that Rangarajan's case, what's that? Where Supreme Court said, look here, if you're a public official, Otto Shankar case. Supreme Court said, if you're a public official, you can't say, I'm shielded from my misdeeds being exposed. So transparency is another important aspect. So given all the important dimensions of promotion of democracy, rule of law, transparency, accountability, and all that, I would probably think the old law of sedition, unless it is either amended I think with some reasonable restrictions, I think the whole law of sedition must go. Otherwise, we'll keep on debating as is. We'll have a new debate on what is nationalism. We'll have a new debate on what is permissible nationalism and what is fascist nationalism. So we have all kind of on the one side, on the one hand, journalists and writers talking about unacceptable norms of nationalism, which are extreme on the one hand, and on the other hand, people saying the very notion of nationalism understands and comprehends what it ought to be, and therefore we are now into an unwarranted a social and a public debate, which can be given a quietus by what I think is the giving up the law of sedition. And once freedom of expression goes beyond the law of sedition, then it will meet its proper field through a properly regulated constitutional framework. And I think I look at this question, to how much is justiciable to link attack on sovereignty of nation with the freedom of expression. The last few days, 3 journalists were charged with sedition for showing so-and-so as martyrs. Also, we know about Pulitzer Award controversy in the last few days, how it showed as Indian-occupied Kashmir should state curb such expressions or let them free hand under Article 19(1)(a). Now, how do we answer this question? Do we answer this question by saying, I read Article 19(2), the interests of the security of state or the integrity of India. Now, on the one hand, there are a set of people and groups who are interested in displaying what the government of India has done as far as Kashmir is concerned as the most unacceptable thing to have been done. But on the other hand, if the government, according to its constitutional understanding, had done it correctly. Now, the debate is between an attitude or an understanding or a position in both in social, political and international life that government of India is wrong in what it has done and what it's continuing to doing. Therefore, if those who have engaged government of India in a violent attack can be shown as martyrs, I think somewhere something is wrong. So government can certainly come in and say, and who will qualify as a martyr? Not certainly within the territory. So if a martyr is someone who lays down life and liberty for the sake of public welfare, for the sake of, let's say, the welfare of a larger number of people, or the welfare of a very important cause, and so on and so forth, which nationally is acceptable. Then you again get into issues of nationalism, so on and so forth. But I think in my personal view, I don't know whether somebody could be shown as a martyr and the government can simply say, well, yes, I allow your freedom of speech and expression. But on the other hand, it can be argued still legitimately, what is being done is only a portrayal of a point of view. You may criticize it. You may oppose it. You may say it doesn't qualify even as a piece of martyrdom. So question ultimately would be, should we engage on a debate where the level playing field is well drawn and where the concepts and principles are equally clear? When we have lopsided understanding of freedom of expression, well, yes, I may call somebody as a martyr. But as long as we have this lopsided understanding of freedom of expression, these debates will continue to come.
Ishan Basla, what is your take on Shaheen Dhaba's case for being arrested for expressing her views in those events on Bal Thackeray's funeral? Does such instances fall within the criteria of reasonable restriction because people still are being charged for such offences?
No, if you lay that, I think the Shaheen Dhaba's case is an excellent example. Now, I remember an instance of people protesting, at a funeral site in US, and that was about a funeral of probably a Jewish person. And this funeral protest site talked about engaged in anti-Semitic views, and talked about the draft and so on and so forth. I think I'll come back to the citation of this case. The US Supreme Court said they have a right to protest in the way they have protested. So that doesn't amount to promoting, hatred among sets of people. The question is, therefore, it's important that what exactly you want to communicate. If what you exactly want to communicate is something, because again, we land into certain very, big controversies. Will it be of interest to general public? And general public mean whom? The ordinary common citizen, the well-informed citizen, the illiterate citizen, or citizens who would be swayed by rhetoric? We have all these problems. So can we draw a common standard? But I think one fundamental line can be legitimately drawn. That is it a statement being made at such circumstances? Does it serve a larger public purpose of enduring value? A larger public purpose of enduring value. But if it only serves a fleeting political or a personal, expression, perhaps the standards would be different. I would probably pitch it very high. At whatever circumstance, if somebody wants to make a statement, a view, etc., it must serve a larger public view and of an enduring value, and which probably will become part of our entrenched civilized social order in due course of time. That's how I will pitch it.
Abhay Gupta, freedom of speech vis-a-vis media trial. Does media trial hamper administration justice? And what could be taken to curb that?
Well, when I was a member of the Law Commission, I think we had this occasion to look into this. The Law Commission has given some reports and whether media trial hampers the administration of justice. There are no clear answers to this question. Question is, I see something on the screen. I read D.H. Lawrence, Lady Chatterley's Lover. I read some other book explicitly talking about, human beings engaged in sexual activities. I read something else. How does it impact my mind? The impact on human mind will necessarily vary and in a wide range of degrees. Question is whether a judge sitting impartially, which should be uninfluenced by any statements, any portrayals, any presentations, will a judge's mind be influenced? I have come across statements when we are looking into this issue. Number of judges have said sometimes we feel influenced. We become conditioned. So the human mind necessarily becomes conditioned in certain circumstances, but not all human minds. So the ability to overcome or not being conditioned or affected by public statements in media, if you are sitting in as a judge, I think that ability must be generated, must be cultivated. And if, on the other hand, you say no as an invariable proposition, whatever media says will necessarily go deep down into the mind and heart of a judge and unconsciously affect the administration of justice. And therefore, media should never say anything on these issues. Would be too broad a proposition. And on that question again, issues have come whether you should have an internal self-regulating mechanism or you should have a regulation from outside. I think my answer would be, again, one common answer. Whether it is regulation of any institution, such as a media, or regulation of individual expressions, there has to be a combination. I don't think appeals to conscience and good sense alone will suffice. Different people respond differently to appeals to conscience and good sense and justice. And even when you have a regulatory mechanism, we always tend to overcome it in some way or the other. All of us know that there have been writings on the corrupt state of the media in different parts of the world. So if there can be a succumbing to a variety of external factors, and you can intimidate or you can succumb. So self-regulation to some extent, and which can be monitored and supervised from an external point of view, and a reasonable regulation from outside, a good mixture of external regulation and an appeal to internal restraint. And then appeal to internal restraint, I think, is a matter which bridges ethics, morality, and how we train our mind in schools, in universities, in colleges, and also, let us say, in the legal profession. So, therefore, tell me.
So, Sumiti Jain, unmuted him. He wants to ask.
I'm not able to hear you.
Deputy sessions. He's an assistant professor. Sumiti, so now you're able to hear me?
Yeah, I'm able to hear you.
Hello. Yeah. So Sumiti Jain has been helping us in various sessions by his inputs on the chat box, and he had certain questions. I've unmuted him. He will ask you directly. Over to you, Mr. Jain.
Thank you, sir. First of all, good afternoon, sir, for such an enlightenment to all the students. Sir, am I audible to you?
Yeah, you are very audible.
Okay, sir. Sir, I just want you to put some light on the current scenarios. Like,
Sumiti, slightly come closer to the mic.
Okay, sir. Sir, am I audible now?
Yeah, you are. You are audible to me.
Sir, as one point, I want to know that the freedom of speech and expression, it is related to only for the citizens. And I just want you to explain that how it affects the juristic persons, as most of the works are now done by the companies. Like in Bennett Coleman case, it was also illustrated by the Honorable Supreme Court. So I just want to know that what is the take of this article on the juristic person, sir?
See, if you look at the Constituent Assembly debates, interestingly, you find whether Article 19(1)(a) or fundamental freedoms, some of them should be confined only to citizens and also non-citizens. It was a very engaging debate. But then ultimately, when the Constitution came to be enacted, we have, except Article 21 and 14, talking about only citizens enjoying the rights. In the context of Article 19(1)(g), whether a shareholder or a person having an interest in a company can approach Supreme Court under Article 32, was alleging violation of fundamental rights. The court ultimately settled that question in R.C. Cooper's case in 1984 later. So the shareholders of a company as individuals may have an interest in the prosecuting the functioning of the company. But if you simply borrow that illustration and bring it in the context of Article 19(1)(a), you may have some problems. Suppose, let me say, I as a shareholder of a company and express my opinion about what the company will be doing or likely to do in a given circumstance. And the company takes a different point of view internally, let's say. Look at a situation like that. So can we say the shareholder right to freedom of expression will be protected and the counterpoint of view of the company will not be protected? So there, the meaning and the concept of a citizen may have to be mutated and see if a company has a counterpoint of view and express again through individuals. But then it says that the company's point of view. So the company is the legal person, but it expresses himself through directors and shareholders and so on and so forth. But the question is, can you prosecute a company for a statement expressed by a shareholder or a director of a company? Or let's say if a company engages in an advertisement, which is offensive to, let's say, morality, or it engages in advertisement which may be falling foul of Article 19(2). Now, what is the purpose of saying a company should enjoy the protection of Article 19(2)? It doesn't serve any particular or additional purpose, because if ultimately you're going to prosecute the shareholders and the directors, the protection must go to them. So this is, I don't know whether there's need for expounding on any further constitutional principles on this. Except I don't know whether a prosecution will lie against a company in the circumstances.
So point well taken. So since we are about to complete the session, generally in this platform we are asking how to become a good lawyer. But today, after seeing your resume and what we had during all the session, I just thought that we should have some different take. So, what was your experience as a member of the Law Commission?
In what respect? In what respect?
In all respects, as a personal knowledge enhancement.
I will.
Otherwise,
Firstly, I enjoyed my 2 tenure in the Law Commission. Now, having been a professional, all of us, as litigating lawyers, have a certain air of freedom about us. We want to enjoy, the way we conduct our profession, and then we don't normally want to be told, subject to restrictions and so on and so forth. Because every counsel will have a counterpoint of view when a client goes to more than one lawyer. So we have that freedom. And when I went into the Law Commission, now look at institutions, how they really function. A court with multiple members, high courts, Supreme Court, with multiple members composing the court. So also a cabinet. So also places where a board of directors. So we have any number of examples where more than one set of people have to sit together, deliberate, think, reflect, and have some kind of a consensus. That kind of a common engagement is a very important process where you begin to reflect on how you can think differently. You begin to sharpen the edges of your thinking. You soften them. Suppose I hold a point of view very strongly, and I have 10 members of the Law Commission having 10 points of view. The question for me is whether I should be aggressive and try to impose my views on everybody, or should I try to understand where do we reach ultimately if all these 10 points of view have to be gathered together, and what's the common denominator, what's the common takeoff? I think the difference between sticking to one's point of view and the difference between traveling to a common point of view to serve a common public purpose, this I think was a very important experience for me. And secondly, and the internationally, the law commissions have taken different routes and forms. Even in countries like in Africa, some of them have gone far ahead of India, and to the extent that they've established legislations under which law commissions will be, formed and from periodically. We don't have a law relating to the law commissions. And if you look at the history of the reports of the law commissions being translated into legal reforms, well, you find about out of 280 and odd reports, about more than 150 have been translated. But then they are translated because the governments probably felt for political, ideological, other reasons, it's good to be translated into practice. So in England, there is a new trend which has now evolved. The English Law Commission's reports are placed before the Parliament. And the Parliament, within 6 months, will have to give a report on its understanding and its acceptance or rejection of the report. That government's response to the Law Commission's recommendation will be debated in the Parliament. And after a debate, if the response of the non-acceptance, the reasons given, non-acceptance or not, say parliamentary acceptable, then the Law Commission's report becomes binding on the government. So the relevance of such a procedure is people's participation in legal reforms get facilitated. So I think it's important that the legal reforms and people's participation in legal reforms will be greatly facilitated in India if we have a statute and we have a properly structured law commission which will enable and facilitate a good deal of people's participation in legal reforms instead of mere ad hoc consultations here and there. These are my takes on my experience in the Law Commission.
So further on the Law Commission itself, like you said that the 10 people were there just for our professional and a different perspective. You said that as you would appreciate, the higher you go, sometimes there is an ego problem, etc. How could one, while working on a bigger platform like this, assimilate all the points and then come to a common point which can be actually put forth? What is your take?
No, we may not ultimately have one common point of view, but then we work into degrees of acceptance. Sometimes there is a compromise, and the compromises are very finely worded. I remember when there was a large number of representations regarding 498A, and there was a demand that 498A should be repealed. So the Law Commission, we spent considerable time on this and said, no, 498A cannot be repealed merely because the law is being abused. The abuse of legal process is something very common. So merely because law will be abused, if a law which is otherwise productive of common good and will prevent a very important common mischief, then in that, while working out the fine-tuning processes, like we said, like the pre-arrest process should be regulated, the pre-arrest process should be supervised, we can bring in a lot of regulatory mechanisms, so where the abuse can be to a large extent taken care of. So that is where the degrees of accommodation, fine-tuning, so on and so forth can be brought in. Of course, there are issues where there are two fundamentally opposing points of view. Very difficult to reconcile that. And very often you see the US Supreme Court decides on a 5-4. And we have recent examples, the Kerala, temple matter, and so being referred to a larger bench by a 3-2 division. So there is division of opinions in among judges and division of opinions among ministers and institutions. I think you just cannot avoid it. And that's part of a diversity of human minds, and working human minds.
You had also been a part of framing of the Constitution of Nepal. What was your experience and how it is slightly different?
Only one aspect was Justice G.S. Verma, the former Chief Justice, was invited to Nepal. And we were part of a team which went to Nepal to share Indian experience in the Nepalese constitution making exercise. One of the important aspects we discussed was about the federal structure of India and the federal structure in the Nepalese constitution. If you read the Nepalese constitution making history, even today, the federal structure aspect has bogged down the Nepalese constitution making exercise. Fortunately for us, I think, regardless of all the little battles we are, engaging in, the little skirmishes on language, religion, culture, so on and so forth, India's federal structure has managed itself, extremely well. I think that's where the a little slips here and a little omissions there, and a little excess here and things like that within the political sphere. Somebody, for instance, if you go back in point of history, the Namboodiripad government was the governor gave a report that the government emergency under Article 356. So the first occasion when the Congress government thought that has put our hand into using constitution for the purpose of destabilizing governments. So we have seen all that exercise of power by governments or governors over a long period of time. We had a recent example in Madhya Pradesh. So these are use of the political processes through constitutional means to the extent they are legitimate. So I think this is what we discussed in the Nepalese constitution making on federal structure. I said you can't have a rigid rule. Rigid rules create frictions. Rigid rules in any form of governance create frictions. Flexibility brings in accommodation. Flexibility provides for more than one point of view to be debated openly and transparently. So that's what's happening in our country. I think we should cherish and then as far as possible enable the flourishing of flexibility and accommodations happening in our country. The moment we don't do that, I think we probably invite a lot of trouble.
So last question, somebody has sent me a text. If a person posts a report of print media report on his Facebook that judicial officers are too young and lack experience, whether it would amount to defamation or not.
Can you come? It's not little clear. Can you read it again?
So the question is, somebody posts on the Facebook that the judicial officers who are appointed in the initial stage, just like a judicial magistrate.
Yes.
They are not too mature. Whether it will tantamount to defamation or not, according to you, what is your take on that?
It will not. There have been instances in the past when judicial officers have been criticized, and I'll give you one extreme example. Justice Vivian Bose, I'll give you an example which is closer, but there are other cases when sitting judicial officer was said to be, incompetent and lacking comprehension and so on and so forth. Justice G.V.N. Bose, in his extended term as a judge of the Supreme Court in 1958, we know the famous Mundra, scandal case. He was appointed as a commissioner of inquiry, and to inquire to find out whether the chairman and an officer of the Life Insurance Corporation were guilty of certain, offences. So the commission's report went against with the government, and Pandit Jawaharlal Nehru made some statements about Justice Vivian Bose, which were very excessive, and about the ability, the understanding, and the intelligence of Justice Vivian Bose. And this was a huge furor in the Calcutta High Court Bar. The Calcutta High Court Bar passed a resolution saying that Pandit Nehru has committed an offence under the Contempt of Courts Act. And then, in the meanwhile, there was a lot of parleys between Pandit Nehru and certain other members in the cabinet. At some point of time, Pandit Nehru apologized to Justice Vivian Bose publicly, and by that time, it was almost about a year and a half. Justice Vivian Bose wrote a letter back to Pandit Nehru saying that I carried nothing in my heart, and as long as I did not feel that I have been offended by what you said, and I understand the circumstances in when you spoke must have been so trying, and I think you have done admirably well in responding in good language. So that ended the matter. The Supreme Court Bar Association, when the MC Settleward was the Attorney General and the President, he said, now the matter is ended there. We don't need to prosecute this issue, deliberate this issue any longer. So a person like Pandit Nehru coming down and saying that I apologize and I acknowledge the wrong which I have committed is a very good example. And I wish people in occupying high public positions, even if they are subject to ridicule, even if they are subject to excessive statements, the question is, do you resort to the criminal process, or do you resort to a coercive process of law and settle issues in the courts of law? So you have the famous case when Jayalalitha filed a case against Dr. Subramania Swamy, and Subramania Swamy filing a case somebody else. So the use of the political space through constitution will go on, and you should not stop it. But as it said somewhere, courts will say what you have done is wrong. Courts will say it is excessive, and so on and so forth. So therefore, it is not defamation anyway. So if it is either, it should be defamation and the contempt of and the, let's say, defamation and CRPC. So scandalizing, using scandalizing words. So you're talking about the incompetence of a judge. Of judges generally is one thing. The incompetence of a particular judge in the context of delivering a particular judgment because somebody is disappointed is a different thing. See, if I'm a disappointed litigant and I talk about this particular judge, then that's a different dimension. But we're talking about the quality of appointment of judges in general. The National Judicial Appointments Commission is all a debate, is all about that. So day in and day out, we're talking about the importance of the quality of appointment of judges.
So last question, your views on expressing dissent on CAA and NRC, whether it will fall within the any restriction, etc. What is your take? It's by Himanshu.
You can't say at the threshold that somebody who wants to protest against CAA and NRC are prohibited under law. It must be settled through due process of law. But whether the protests are one thing, whether the contents are legitimate is entirely a different thing. To say that because you disagree with the contents, and the court may ultimately disagree with the content, or the government disagrees with the contents, well, that's a different issue from saying, I will not even agree with you for protesting against this. Because the open space of exchange of views is democracy. Even the most extremely unacceptable views which are hostile to your understanding, and they must come, they must be expressed. But whether they will stand the scrutiny of reason, they stand the scrutiny of justice, they stand the scrutiny of the Constitution, That will be a different issue. They may all fail at ultimately. But to say that, for instance, I always think of this, the Hyde Park in London is said to be a place where people can go and protest. So our constitutional spaces must be like Hyde Parks, not easily closed, not lightly prohibited. Our constitutional space must be as broad as possible. But once we enter the constitutional space, and if you want to enter the constitutional space, you must know that your stand, your words, your understanding, your principles, your perspectives will definitely stand the scrutiny of the Constitution. If you're prepared for that, enter the constitutional space. If you're not, if you have doubts, then you're entering the constitutional space like the gladiators. Right? That's how the game will be.
Thank you, sir. It has been a wonderful session. Can I ask your son to chip in because he has been a backbone to your entire this?
Yeah. I'll ask him. He can. Yes.
Yeah.
Yes.
I don't know. I mean, I'm dwarfed by anything that
You
Mr.
can come in the
Venkataramani
center.
says. I don't think I'm in any position to comment or say anything after Mr. Venkataramani has.
We are not asking you to comment upon anything. It doesn't behave well also on our asking. We just wanted to know how is your take while taking with your father as a lawyer and as a father in his own space. Only on one comment, and thank you for supporting him from the backdrop.
It's you're constantly at the pressure of filling very large shoes, and that pressure at some level is always at the back of your mind. But it is an excellent opportunity to learn from the evolution, how the practice is taking place, learn from the evolution of law. As you would have also seen in this speech, it would have been fairly easy to simply talk about 7 cases, to talk about this is what the standards of the law have been. But to constantly get an experience of having someone who's explored the law and the context in which they have been expounded. And it always gives me an opportunity for a more
R.Venkataramani, could you
fundamental
slightly come closer to the camera? You can come in the middle of the camera.
Right. So, while it's always intimidating to, the expectation is there that you would have to fill large shoes. The advantages at the same time, aside from the networks that you have access to, is the fact that you have the ability to sit with someone who's had 40 years of experience in this and apply it to contemporary modes of how the law practice is taking place currently, as well as understanding the evolution of law, not just from a perspective of saying this are the 8 cases that you have gone through that these cover the subject, but understanding the context of it all. So I am always in a position where I'm trying to understand the basic concepts. As important as this to be able to know how to apply it in the current context. So I think in a couple of sentences, it's both intimidating to be around him and constantly feel inadequate in some ways. At the same time, having your ears open and grappling all the opportunities that you can get, both in learning as well as in connecting with people, including this opportunity to connect with all of you.
I stand corrected. Somebody made me corrected that you are Anand, not Arvind. Thank you. It was always an Anand meeting, both of you on the platform. We have along with us Mr. H.S. Brad. We call him by Rajan. He has been the former president of Punjab and Haryana High Court Bar Association. Plus, he has also been the chairman of the Bar Council. A formal vote of thanks by Mr. Brad. But before I ask Mr. Brad to come out, so words cannot express the knowledge you have shared in such a short space. And what Anand shared with us, you actually feel that it is very, very difficult to come into the shoes once you come, bring a person on this platform having such a knowledge. Sometimes you at the back of the mind and the back of the hindsight, you also get a feeling that you are also into law, you are also studying law. Why he has that much knowledge, he also has those 24 hours. What I should do better to sharpen my razor skill knowledge. Thank you, sir, and over to Mr. Brad. Rajan, you can just take over. Harpreet.
Good afternoon, everybody. I have been entrusted with the duty to propose a vote of thanks So I, on my behalf and behalf of the entire team of Beyond Law, place my heartfelt gratitude to Mr. R.Venkataramani, a senior advocate, for joining today's webinar and being a keynote speaker on the topic of right to free speech. Mr. Venkataramani is a first generation lawyer, and his life journey is a very inspiring success story to all my young friends and also to all of us. He has the privilege to join the chambers of the great constitutional lawyer of this country, Mr. P.P. Rao, and he is one of the most erudite and accomplished lawyer in the country and a leading light on the indirect tax. He had been member of the Law Commission, and he has made great contribution for the development of law, not only in the India. He's an internationally acclaimed a legal giant, and we are all privileged to have him with us. And I will be failing in my duty if I do not acknowledge the initiative taken by Mr. Vikas Chatrat and his team to invite us to this intellectual feast. The right to speech is such a topic. It has made great strides ever since the judgment of Tata Press versus MTNL, where the question posed to the Supreme Court was whether the commercial speeches is a free speech. And Mr. Venkataramani has very incisively enlightened all of us on the provisions of Article 19. And I thank all of you for participating in this webinar. Thank you very much indeed.
Thank you, Rajan. And sir, I would just like to apprise you. Probably you would have met Brad because he's an active lawyer,
I know about him.
Yeah. So just to introduce Rajan, that he's like this thing, it is just to tell that you are on the sky, there is a sun. He's a sun where everybody aspires to look upon him. He brings brightness to the entire Bar Council of Punjab, Haryana at least, and Pan India also. We all look upon him in a young career. He has risen like anything. He's an inspirational story for many lawyers and other professionals. That being a first generation lawyer, you are creating a niche in the politics. He's dabbling the politics and advocacy in a very right way. And thank you, everyone. We will connect. And tomorrow we have a good webinar. And that is on interplay between the tax laws, including GST and the Constitution of India. And that is by Mr. Kevin Gulati, senior advocates. Do stay connected upon us. Stay safe, stay healthy. Thank you, everyone. Thank you, Rajan, and thank you, Mr. Venkataramani.
Thank you very much.
Thank you.
For being so
Thank
kind.
you. Thank you.
I don't
Thanks
deserve
to all of you.
Please. Thank you.